Welcome to We Chat Divorce, hosted by Karen Chellew, Legal Liaison, and Catherine Shanahan, CDFA. Each episode, we sit down with divorce professionals and industry experts to provide insights and frank discussions about real people, real situations, and real divorce to help you achieve your best life post-divorce. This episode of We Chat Divorce is brought to you by My Divorce Solution, offering divorce financial planning so clients can secure the divorce settlement they deserve. Visit mydivorcesolution.com to request access.
Welcome to We Chat Divorce, brought to you by My Divorce Solution and hosted by myself, Karen Chellew, Legal Liaison, and Catherine Shanahan, Divorce Financial Specialist in CDFA. On these special explainer episodes, we answer the top questions about divorce, giving you confidence and clarity.
Today, we are going to talk about mediation remorse, the day after, and why it matters to you. So let's get started.
Mediation can seem like the perfect solution to couples who want to resolve their divorce in an amicable way. However, many people have false beliefs about the mediation process, and today we're going to cover some of that territory. There's been a growing trend for divorcing couples to consider mediation. According to Forbes Advisor and other sites, about 70 to 80% of mediated divorces end up with successful agreements that endure over time. Let's think about that. So first, what defines a successful agreement? Would that be an agreement that is signed by both parties on the day of mediation? I think most statistics, attorneys, and mediators would agree that that is a good definition.
Well, Karen, is that a good definition because it's over with for them? You know, some of these mediation sessions are grueling. They're 8 hours long. And so do you feel like because you're coming to an agreement at the end, it's just because it's over and we're done and we don't have to do this again?
I think that that is what statistics and/or the industry would consider a successful agreement. Do I agree with that? No. But I think what the definition is that there are signatures on a document that confirm that the parties have agreed. So
Yeah.
second, what is the definition of the term an agreement that endures over time, right? So that would probably make most people feel fairly confident. So would that be an agreement that is binding on both parties that can't be revised or retracted? Yes. So that's the comfort phrase. However, while most couples I know who end up with agreement could not dispute the above, right? They have a signed agreement that may need to be more formalized after mediation, and the agreement endures over time. However, Catherine, you and I know that many people who engage in mediation and in the day signing an agreement wake up the next day with what we call mediation remorse. And why is that?
Well, again, there are several reasons and we can review some of them. But let's just start with many people engage in mandatory mediation in a court proceeding because all parties have fully disclosed assets and debts and are agreed on values such as real estate, pensions, and businesses. It is common for clients to put their full trust in their attorney who advised them to mediate before these steps are completed, and then at mediation insist that they settle for the offer on the table because one, they will not get a better offer later. So that's a huge reason, you feel bullied into it because you're afraid of going to court. Two, they don't have enough money to spend on their attorney to represent them at trial. And again, they're not going to get a better offer later. Or you don't want a judge telling you something at trial and you can't afford to go to trial. So imagine the dismay of undergoing this level of pressure to make this permanent decision in that moment, and especially after being in there for 5, 6 hours.
Yeah, I know we often caution our clients to speak with their counsel and or make a decision if counsel are not involved and they're in mediation. Just pause at the end of mediation and say, I will consider these terms. I feel like we're in a good place in this moment, but I want to, make sure I understand all of the provisions. So, I don't want to sign today unless they fully agree with that. So I do encourage them to talk with the mediator about that and their counsel to just talk about those options at mediation. I just spoke
It,
with a client yesterday who had completed mediation. She talked with her counsel ahead of time that she didn't really feel comfortable signing anything at the end. And I asked her, I said, did you hear these phrases? A, this is a good settlement. She said, yes. I said, did you hear the phrase that if you don't sign today, then we're going to have to go to trial and I need $20,000 or more in a retainer? She said, yeah, actually, they asked me for 50. But that particular client, we took the mediation terms, assets were missed, provisions were missed, disclosure of information was missed, and it was a very unbalanced division of assets when you actually built it out. So, she was just so thankful that she didn't sign anything because they are back at the table now, clearing up some of the issues that were missed and balancing the division of marital assets.
well, she's fortunate enough that she did have the courage to say, listen, I'm not signing that. I mean, I was recently in a mediation where, I was really excited because our client's attorney was like, listen, you're not going to sign anything tonight. I'm really anal about details. I was like, wow, that's great to hear. But do you know at the end of that mediation, the mediator got so angry and called a sidebar, like asked the two attorneys to go out and talk to her in her office and saying, you're going to sign this today. And they came in with such a different viewpoint. Listen, we're going to sign this, but we're going to take a little time more now to review it a little bit. But it also amazed me, like, why are they succumbing to, okay, we have to have this signed today? And, again, the mediator used the tactic, if you don't sign this, your spouse is not going to agree to anything. This is not an agreement. And I felt the pressure there a little bit. So I get that many people, although they want to say, we don't want to sign this now, there's a lot of pressure you feel from everyone involved. And I think that's why sometimes mediation isn't set for everyone. Maybe you do have to just walk out and say, I'm not signing it, and throw the chips up in the air and see where it lands.
Yeah. But let's be clear, mediation is a really effective process. But what's missing is the disclosure and confirmation of key and supporting documents, right? How do you go to mediation if you don't know what you're mediating? If everything hasn't been valued and all the disclosures haven't been completed. In this particular case, I was referring to a couple minutes ago, we discussed that with the attorney that there were, a lot of missing documents that we needed to affirm the values and so that both the attorney and the client would have everything needed to effectively get through a mediation. And so she had reported to us that at mediation, she would use that time to make sure all the documents and um, assets and debts had been verified. Well, unfortunately, that just didn't happen. They went right to negotiating a settlement. So, that's the missing piece. And that's why my divorce solution exists to close that gap of preparing and understanding and knowing what you have, what your options are, and then going to mediation. And then you can be very effectively involved with negotiating a settlement. It's just very difficult.
It really is. And you know what? Along with the difficulty is it's fearful. Like that's a scary situation to be in when you feel like you have no control. And you think you're going there, like you just mentioned, your attorney is saying, listen, we'll get all that information before you have to mediate that. But we'll do it during mediation. It's our best way to get the information. Then you get there and you're expecting that, and then you don't get it. So what do you do for the next 5 hours?
Absolutely. And these court mandated mediations are, under court deadlines and, you have to report to the court process. So a lot of times those mediation dates can't be altered. You have to show up with what you have. And so again, that's just some kind of breakdown in the financial discovery process where all the, you know, I's have not been dotted and the T's have not been crossed because you're going to do it later or whatever. We were involved recently in another case where spouse had not disclosed all of the assets that um, he had access to, and our client's attorney said, well, don't worry, by the end of this case, we will cover that territory. But in the meantime, they were still going to mediation. I don't know what to do what, but quickly the attorney agreed that disclosure was important to have an effective mediation. And I think a lot of people don't have the ability to discuss that with their attorney or even the autonomy to make a different decision, because when it's a court mandated mediation, there's you have to go.
Well,
So that's
know,
tough.
yeah, it is tough. I agree. And it's also tough because I'm hearing time and time again that attorneys aren't even reaching out to their client till the week or so before mediation, because it's not
Mhm,
an emergency to them. So you're sitting on this end, and now it's too late to reschedule some mediations, people feel. So
mhm.
you really need to find out sooner than later. Are you prepared for mediation? Because I agree. I would like everyone to go to mediation when possible, right? But when do you go? You go when you're confident with the information that you have. And if you're not, you need to reschedule that before you're pressured into making an agreement that you don't want to make, or you're
Yeah,
not ready to make, I should say.
right. It's very difficult.
Remember, at the end of the day, everyone goes home to their lifestyles later. And your
Hmm.
lifestyle might be changed dramatically, and it probably is. So you have to be clear on that before you go home, because they're all going on to their own respective lives. So you're the one stuck with whatever that agreement is. And I do believe you have to compromise, but to what level are you compromising? And if you don't have a clear understanding of the impact to that, then you should not be in mediation.
Absolutely. And conversely, couples who decide to use mediation instead of attorneys as a first run because, they have their balance sheets kind of worked out. We often talk to people in that space, and they too still experience mediation remorse because what their balance sheet looks like to them when they're managing their household is very different than divisible assets and debt in a divorce proceeding. What's marital? What's separate? Is there a date of division of assets? What's the difference between the values of 401k accounts versus equity versus values of businesses, things like that? There's a complete misunderstanding. Even with accountants and financial people, it's just because how the divorce industry looks at these types of divisions is very different than how people manage their households. And it's very, has very, a lot of financial impact that most families can't even anticipate if they don't
Yeah.
know.
If you're listening and you hear what Karen just said, it's so important. If I could just pull out one example of that so it can
Hmm.
resonate in your mind. Separate property. You hear a lot of people who do their balance sheets, and a balance sheet doesn't have all the details that Karen just mentioned. And one of them is that separate property. You might both agree, yes, we had that account prior to marriage, or yes, that was an inheritance. And yes, I do understand that. And you automatically put it onto that spouse's side of the column. But is there documentation to prove that? And was any of that money commingled during your marriage? And what was the intent of some of those accounts that were set up? Those things could really change where that money goes on the balance sheet. And until you have the clear understanding of that and the documentation to support that, then you might not want to prematurely negotiate that away.
Absolutely. Knowledge matters. Think about that, right?
Hmm. Knowledge is everything. So thank you for joining us on this second episode, Financially Planning for Divorce.
Stay tuned for future episodes as we continue to unravel the fascinating world of finance and divorce. And remember, knowledge is power. Disclaimer: the information provided in this Divorce Explored podcast is for educational and informational purposes only and should not be considered as financial or legal advice. Please consult with professionals in the relevant fields for personal guidance.
Thanks for joining us on another episode of We Chat Divorce. We hope this episode was informative and supportive on your divorce journey. If you're looking for more support for navigating divorce with confidence and clarity, head over to mydivorcesolution.com for more podcast episodes, divorce events, and resources for your divorce. We'll see you back here for our next episode.